Alright, so this is Diesel We the People News. Okay. One more time, we're at it. Learning, learning, learning. Never look straight forward, always look around us, be able to protect ourselves by any means necessary. It never ends. Standing on your rights is a never ending battle. Okay. This one, per se, is Bud Brownville, LLC. Okay. Spell it just in case. B-U-B. B-U-D. Brownville LLC. Okay. So if you want to, go check out his stuff. Okay. Rebut, rebut, reboot. Most people call it rebuttals. Okay. But it's a reboot. All right. Now, a few months ago, I did actually, a lady did a reboot, and she read it out with her hands and all that. If you're scrolling back, this is how you reboot. All right, but didn't really get into great details, and I'll probably make two-part video on this, but I want to get you guys started on this, right? Because she wasn't speaking out of her behind. Okay, there is a canon on this. Let's proceed forward, and our judges use it. Now we're under the pressure before we're stepping forward. Okay, I'm not giving legal advice. Okay, I'm not an attorney. Do not care to be one. Okay, this is a learning video, entertainment purposes. Okay, so anything I say or do is just hearsay. Ignore me. All right. So check out my previous video, but this is kind of like a follow-up. But I came across this on accident, and it kind of a little bit more clarifies it. I'm talking way too much, way too often. Let's proceed forward on this. Alrighty. What did I just do? Gee Louise. Alright.
All right, so what we're going to be talking about is rebut, rebut, rebut. Any unrebutted affidavit stands as truth. Any unrebutted.
Okay, let's stop there again because I got lost track of thought. So we're under the impression that we are innocent until proven guilty. But anybody that makes claims, judges, lawyers, anybody, you're technically not innocent until proven guilty. Okay? Why? Because they want you to make some type of plea. They want to turn around them being the claimant for you to be the claimant. So you must, wink, 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 you must enter not guilty, guilty, or no contest. Right? Well, you just turn from them being a claimant to you being a claimant because you just made a claim. But nowhere does it say innocent. All right? Not guilty is in fact guilty. They just could not prove it. But you're still guilty. Is how that works. Then obviously guilty is guilty. No contest is guilty. So all three things that you're claiming, you're guilty. Why? Because you're not innocent. Anyway, let's proceed forward.
But an affidavit stands as truth. I said this before, I'll say it again. If I call you a bitch and you sit there quietly, twiddling your fingers, look up into the sky, you don't respond, you're a bitch. But if I call you a bitch and you say, who are you talking to? I know that ain't me. I ain't no bitch. Do you respond? You're rebutting. That is what you have to do with these cases, with these processes. If you are served something, you must answer. I have individuals that say, who are they that we must answer them? I'll I'll say it like this. You will be guilty by acquiescence. You do not want to fight your way out of the hole. You want to make sure you never see the freaking hole at all. You don't want to be on the defense. Did I say that right?
So again, y'all, sit and think about that. They are lying to us that we are innocent until proven guilty. Right? Everything's rebut. Okay? You got to rebut everything. So therefore, how can you be innocent until proven guilty? If you, in fact, have to rebut everything?
You want to be more offensive than defensive, meaning before that ball is thrown into your court, you want to swipe it out the air. When that basketball is thrown up against that or attempted to be thrown into the basket, you have until it starts to come back down. Those that know basketball, you have until it starts to come back down before you can swat it. If that ball is tossed up and you swat it out the air, fine. If you hit that ball as it's coming down towards the basket, then that is a goaltending. You know, so there is a time and a place for everything, and everything has to be addressed accordingly. All right, so I don't want to start with this one. Let me start with this one here. And this is a pretty well-known case. I am not going to go into the details of the case. That's not really much what I do. I present the stuff for you, and you need to do your due diligence. There's a reason why I am showing this to you, which means I've done my due diligence, and I use this as a reference. If I didn't do my due diligence, I wouldn't be able to use it as a reference. But I've done the prerequisite homework on my end, so that's why I'm bringing it to you, and you can do the research on your end. We got to do this together. I can't do everything for you. All right? With that being said, bench. I have considered the defense motion, and that will be the judge. I have considered the defense motions, and they are all denied. Real man, I did not file any motions. I filed affidavits. Bench, meaning the judge. Well, I am retreating your documents as motions. Real man, again, I did not file any motions. I filed affidavits. It is a criminal offense to file a false affidavit. I notice I am not under arrest for filing a false affidavit, so it is clear that my affidavits are true, correct, and accurate. An affidavit is a statement of truth, so my uncontested affidavits are the truth. I'm sure this court isn't deliberately denying the truth in order to falsify the record. I'm certain it isn't this court's intent to falsify the record and create denial of due process, is it?
Okay. Now, we talked about attorneys and all that. All right? Do attorneys write like this? Do they enter the court speaking this way? Or is he doing this standing as a man towards a servant? Okay, so let's get this clear. All right, the languages, we're not bound to their type of rules, regulations, and statutes and codes. They like for us to be, but we're not bound to it.
It's the case of Mars v. National Cash Register versus Group v. Finletter. Defendant is likely to be the only individual now or in the future who is willing and able to place a sworn affidavit affirming the herein disclosed facts under penalties of perjury into the record of this case, and as such, in the absence of a sworn counter affidavit signed under the penalties of perjury regarding these same facts, laws, case laws, and evidence, defendant should be the only prevailing party. Mars v. National Cash Register, 44, SW 2D 433 clearly states at point number 4 that the uncontested allegations and affidavit must be accepted as truth. And the federal case of Group V Finletter 108 F Sup 327 states allegations and affidavit in support of motion must be considered as true in absence of counter affidavit. Now for the
Okay, so for there, right? When people call the police that someone looks suspicious, right? Really, technically, the people that called in needs to sign an affidavit under penalty of perjury. Okay, they kind of contribute everything to your neighbors telling you you're on your neighbors, right? A Russia kid told on his dad because they called the Russians communists, right? And the people came in, the soldiers came in, took the kid's dad, and killed him. And he became a hero because he told on his dad. Well, that's what they are teaching us here. They're teaching your neighbors and your family members to call in on you. And you do not have to have an affidavit. Wrong, you do. You got to challenge that standing. Right? They're the claimant. They must have an affidavit. Well, like attorneys, Houston. Who's the man or woman named Houston is making the claim with an affidavit under penalty of perjury? They're not doing it. This is how they're violating you.
Listening that heard me read those case notes, the citations. Never mind, I'm gonna do it. I'm not even gonna do it. Anyway, let's go over here. Are you familiar with this document? You need to be very familiar with this document.
Everybody needs to be very familiar with this. Period, y'all.
And in 3, 2, 2.
It's the 12 presumptions, okay, that you must rebut 12 times.
8, the 12 presumptions of court. Please Google this, look it up, and read it for yourself. What I will read out of this one will be summonses, and I think I'm going to read the guilt part. Let's go to summonses. The presumption of some.
Let's back up a little bit.
And read it for yourself. What I will read out of this.
All right. Mental picture right there. 1, 2, 3. Okay. Pause my video, kind of read it, write it out or whatever, and then you got to rebut all this on every single case that you have, people. All right. Every single one of them.
One will be some. And
uh-oh, went a little too far. Gee.
Of course, please.
All right, I'm gonna pause there so you can get number 5, rebut. Pause there. Number 6, custody. You definitely want to rebut that. Oh my goodness. Read that and study it hard. Okay? Sorry about this pausing and going. I forgot how fast this was. There's number 10. Number 9. Number 8. Court of trust. Right? You're supposed to go in there and trust them. They're going to do the right thing. Because of the oath of office. But can you really go in there and trust them? They got a sovereign immunity. So therefore, they are legal to lie and be bipartisan and say, well, be one-sided, but they can claim to be bipartisan when they're not. Family courts. Number 11. Number 12. Now, it'd be a little quicker if you look this up, like he said. Okay? This has been long enough. I'm going to go ahead and pause it right there, y'all. Let's see.
Let's look it up and read it for yourself.
Yes.
What I will read out of this one will be summonses, and I think I'm going to read the guilt part. Let's go to summonses. The presumption of summons is that by custom, a summons, unrebutted, stands, and therefore one who attends court is presumed to accept a position as defendant, juror, witness, and jurisdiction of the court. Attendance to court is usually invitation by summons, unless the summons is rejected and returned, with a copy of the rejection filed prior to choosing to visit or attend. Jurisdiction and positions as the accused and the existence of guilt stands. And briefly, in their courtrooms, it is a stage play. It is a well-coordinated, well-organized stage play. And they have actors in there. They have roles. And there are several roles that are available depending on how you carry yourself, how you present yourself, how you defend yourself. Now,
listen to the word. He didn't say represent. He said present. You stand as yourself. Okay? Listen to the words, right? Trickery of words. Okay? Defendant, juror, witness. All right. So why do you want to be a defendant? Right? With somebody making a claim on you. You have firsthand knowledge of what happened. You can turn that defendant into a witness. It's up to you, people. I am not making a legal determination. Okay? But it's an argument case, right? Why do you have to go as a defendant when you are a witness to yourself? Food for thought. All right. Diesel for We the People News. I'm going to leave it off right here, right now. Bye.